Hi, everyone. Welcome to today's presentation. If you guys just want to let me know in the chat that you can hear me well before I get started. Awesome. It looks like everyone can hear me. Just give me 1 second and we'll get started. Okay, so today we're going to be talking about the Public Records Act. So this relates to government entities, local agencies that have, is someone having an issue with hearing? I'll try and talk louder if people can't hear me. So the Public Records Act applies to local agencies and it governs the documents that they have to provide to members of the public. So this is contained in California Government Code 6450. It's analogous to the Federal Freedom of Information Act. So a lot of times you'll see that people, when they submit a Public Records Act request, they'll request information under the Freedom of Information Act. This applies to the federal government, but like we'll talk about later on, requests must be read broadly. So even if someone's requesting under the Freedom of Information Act, we still have to oblige with the request. So the PRA is not a retention statute, so it does not mandate that you retain documents for any mandated amount of time. There is Government Code Section 34090 that local agencies must retain public records for a minimum of 2 years, but some records are allowed to be destroyed sooner. So the Public Records Act doesn't require that you necessarily keep documents. It only requires that you provide documents that you may have still. Also, additionally, prior to Prop 42, the state had to reimburse local governments for the cost of complying with PRA. After Prop 42, they no longer have to do that, so it's all on the local agencies to do that. The PRA is also not a method for free discovery, as not all records must be disclosed. It can help with pre-litigation if you think you might be going into litigation, to just use the Public Records Act to get some documents before you even start. It is also not unlimited market research. So as you'll see later, you do have to make your request targeted and specific. So you can't use it to just request unlimited amounts of documents from a local agency. And it's also not a questionnaire for the agency to respond to. So information covered under the PRA, this is going to be any writing relating to the conduct of the public's business and prepared, owned, used, or retained by any state or local agency, regardless of physical form or characteristic. So you're going to see later on that this goes pretty broad. So what does retained mean? In 2017, the California Supreme Court held that messages sent or received from personal email accounts by public officials and employees that relate to the public's business are considered records under the Public Records Act. So cell phone records are also a public record, regardless of whether it is a city or a personal device, if the records contain public business. So this is actually pretty new, like I said, in 2017. Prior to this, courts had ruled that personal email accounts, personal cell phones, even if they had public business on them, were not considered retained by the local agency, so they could not be discovered under the Public Records Act. This is not the case anymore. So now you must be mindful of things that you're talking about, even in your personal email accounts or your personal cell phones, because they can be considered a public record still. Consultant documents, which are deemed owned by the city by terms of an agreement between the city and the consultant, are also considered public records. And then this is a big one, social media. So discussion of public business on any account by a public official or employee will be considered a public record. So it's a big deal nowadays. So we're going to talk about creating documents. So PRA covers documents, not information. So if the information is not in a document that the party is requesting, it's unlikely to get the answer they're requesting. This is because the agency does not have an obligation to create a document which does not presently exist or has been destroyed. Making a request. So like I talked about earlier, requests must be construed broadly. So if they send you a request for information under the Freedom of Information Act, you still should respond, because you should know that they're technically asking for information under the Public Records Act. This is a big deal. So disclosure is norm, non-disclosure is the exception. So when responding to a public records request, it's more important to disclose than to not disclose, because there's nothing that prevents you from not disclosing, but there is repercussions if you don't disclose something that should have been disclosed. So if something's kind of on the fence of whether there's an exception to disclose it or not, it's always a better practice to just disclose it and not get into a costly legal battle over it. No written request is technically needed, but it helps set the record straight. Like I talked about, nothing screams rookie to a municipal lawyer more than someone requesting local documents under FOIA. So it's always something to keep in mind. A lot of times what happens is, especially, for paralegals, you're using templates or previous requests sometimes, and sometimes you just forget to change out a word or a sentence, and that's where this will happen a lot. So a public records request must reasonably describe an identifiable record or records. So it must be focused, specific, and reasonably clear so that the local agency can decipher what record or records are being sought. So you aren't required to just hand over, like I mentioned earlier, it's not unlimited market research. So if someone comes to the local agency and requests just this overbroad amount of documents, it's not targeted or specific, there's nothing wrong with the local agency requesting that the request be more clear and less broad. So, but that is, I think I talk about this in here. Yeah, if a request is not clear or is overly broad, the local agency has a duty to assist the requester in reformulating the request to make it clearer or less broad. So you can't just throw away the request just because it's not focused or specific. You need to identify what is not clear and make that known to the requester. A request that is so open-ended that it amounts to asking for all of a department's files is not reasonable. And a PRA request only applies to records existing at the time of the request. It does not require a local agency to produce records that may be created in the future. So this happens every once in a while where they'll ask for, like a rolling public records request, essentially. That's not allowed. So if you want documents that might exist 6 months from now, you have to make that request at that time. And I'll just say too, if you guys have any questions throughout, feel free to send them in the chat. I am trying to kind of keep an eye on it to see if anyone has any questions. So the response, this is the most misunderstood part of the PRA. The way it's written is a little complicated, so totally understandable. So this is going to be very applicable for paralegals, especially ones that are making public records requests for their clients. So each agency, upon a request for a copy of records, shall within 10 days from the receipt of the request determine whether the request in whole or in part seeks copies of disclosable public records in the possession of the agency, and so shall promptly notify the person making the request of the determination and the reasons therefor. So a lot of people read this and think that means, let me go back, and think that means that they are going to get all their documents within 10 days. And that's not the case. So what this requires within 10 days is that the public agency notify you of whether they're going to disclose documents or whether they're not, and what the reason for that is. So they don't have to actually give you those documents within 10 days. So that's the part that's really commonly misunderstood. So also, a local agency may extend the 10-day response period for copies of public records for up to 14 additional calendar days because of the need to search for and collect the requested records from field facilities or other establishments separate from the officer processing the request, to search for, collect, and appropriately examine a voluminous amount of separate and distinct records demanded in a single request, to consult with another agency having substantial interest in the request, or among two or more components of the local agency with substantial interest in the request, or in the case of electronic records, to compile data, write programming language or a computer program, or to construct a computer report to extract data. So these are really specific exceptions to the 10-day rule. But they do apply often. A lot of times you are examining a big amount of documents, or there are several departments in the local agency that are involved. In that case, like I said, so it would give you 24 days, but again, not 24 days to get them documents, 24 days to just respond, let them know what the determination was. So, sorry. So the time required to get them the actual documents, there's no specific time stated in the statutes, only that the deadline is promptly. So it's reasonableness based on request. So like I said, if it's one of those ones that you're asking for 14 extra days because it's a huge amount of documents being requested, you're going to be given a bigger time period to respond or to actually get those documents. So like I said, it can vary greatly depending on the request. If it's going to be a 2-page contract, there's no reason it should take more than a couple days once you respond to get those to the requester. So this is also a big part that's misunderstood and forever changing. So costs can be charged if compilation by staff is required. So a lot of people don't realize that you can't just go in and request 500 pages of documents and be handed them for free. There is costs that can be charged. Cost of duplication does not include staff time, so you cannot be charged for the time it takes for an assistant or a secretary or whoever to stand at the copier waiting for the documents to be duplicated, but you can charge for those costs of duplication, the paper, the printing, the ink. Electronic form essentially eliminates any fee recovery. Like I mentioned, there's no paper, ink, wear and tear on equipment. So if someone is requesting an electronic form and the documents are kept that way and you have that ability, you should always give them in that form. And disclosing documents can waive any rights. So this is why it's always important to have an attorney look over requests, because if you hand over something that's privileged or there's some other reason you shouldn't hand it over, it's going to waive any rights that it's privileged going forward. So when you're withholding documents, the notice to the party should read, documents do exist but are being withheld on the basis they are. Some exceptions include attorney-client privilege, work product, law enforcement records, personnel records, etc. So you can't just say to the person that we're not giving you any documents, sorry. You have to really let them know that documents do exist, and you have to be clear in why you're not giving them. So that way, if they want to challenge that, they know the basis to challenge it on. There is a catch-all exception. It balances public interest versus public benefit. So if there's a document that you don't think should be given to a requester, but there's not a specific objection, it might fall within this catch-all exception that maybe the public interest in that document not being seen is greater than the public benefit. I rarely ever see this. Like I said earlier, you're in a better position to just disclose a document rather than withhold it, because then you're going to end up in a legal battle over it. So if you're going to use this catch-all exception, you should have a very good reason to use it. So under the balancing, documents can move from disclosable to non-disclosable or vice versa. So what I'm talking about here is that usually when you're thinking of the catch-all exception, you're looking for an exception to not disclose something, but sometimes maybe something is something is not disclosable because there's an exception, but maybe the public benefit means it should be disclosed. So documents do not hold the same label indefinitely. The facts change, the balancing test. So an example here is litigation costs. So amount spent on litigation can give insight to what a litigant is doing. During the litigation, the balancing test may justify withholding, but the test would fail after the litigation is completed. So this isn't talking about like the specific bills for litigation, but just like the amount of costs alone. Sometimes you might determine that giving someone the amount of those costs would give them some insight into the litigation strategy of the public agency. So while litigation is ongoing, that might be something that the public agency wants to withhold. But like I said, it's a time-sensitive determination. So if the litigation ends 3 months later and the person makes the request again, your determination is probably going to change. So you can't, it's not just a end-all be-all when you respond. The statute allows for permissive non-disclosure. Absent a court order, nothing would prevent the agency from disclosing all documents. So this is what I've talked about a couple of times throughout this, is that just because something has an exception doesn't mean that you can't disclose it. I mean, there's certain things like things that are attorney-client privileged, personnel things that are privileged that you shouldn't withhold or shouldn't disclose, or you're going to get yourself in trouble. But if something, a police report is technically allowed to be not disclosed, if you disclose it, you're not going to be in trouble for that. A court order cannot be sought by the agency prior to withholding documents. It creates a burden on requesting parties. So there are times where it would be nice to be able to have a court tell us, can we withhold this, or are we going to get in trouble if we withhold this? But that would create a burden because it would just take a long time for people to get the documents they're requesting. So we're not allowed to do that. But persons potentially affected by disclosure, for instance, like I talked about, personnel documents, can seek a relief by way of a reverse CPRA action. So what they're essentially going to do is go to the court and request that documents not be disclosed because of some privilege or other reason. So your PRA request was denied. Writ proceedings are the only option. So you're going to bring a writ of mandate to ask that documents be disclosed. The big part here is that the requesting party gets attorney's fees and costs at the discretion of the court if they win. Also, agency attorney fees and costs are only recovered if the request was frivolous. So this is why we have to be careful when we're choosing to withhold documents, because if we withhold something and someone brings an action and they win, they're going to get all of their attorney's fees and costs. So one document is not worth, thousands and thousands of dollars to the public agencies and attorney's fees. Okay, so I don't know if this is hard for you guys to see, but this is kind of what a typical public records request will look like. So they cite, the code. They're requesting documents pursuant to the California Public Records Act, Government Code Section 6250, and then they request that this is just a made-up document, so it's not a real one that we're showing you, but we hereby request that the City of Hanford provide us with copies of the following public record documents related to this project. So this is typically what it looks like. Application submitted to the city for the project by the project applicant, that would be disclosable. Drafts of the development agreement and term sheet, if any, for the proposed project site, that would also be disclosable. And this is what you would do when you would respond. You would say, we have documents, we'll disclose them. We have documents, we'll disclose them. 3, draft petition for formation of a community facilities district for the project site, including any draft or final resolutions of formation and intention to establish a CFD. So this is going to be a permissive non-disclosure. So drafts have there's an exception for drafts in the government code. There's also an exception for called deliberative process privilege. So it protects kind of the thought process and the thinking of public officials before actual documents are finalized. Why we put permissive non-disclosure. You might decide that it's not worth it to not disclose it. The drafts don't, hurt the public agency anyway or make them look bad, so maybe we'll just hand them over. Any and all communications between city staff, legal counsel to the city, things like that. So that's also going to be a permissive non-disclosure, except for the communications between city staff and legal counsel is going to be privileged. So you always need to make sure you're watching out for privileged requests. The proposed realignment would be disclosable. Draft responses to comments received on the EIR are going to be disclosable as well. And then that last request goes along with the deliberative process privilege. So memorandums and letters between staff as they're going through the process is privileged. So you do not have to disclose those. Comments received by the city on the EIR are going to be disclosable. And then this last request is a good example of where something may be too vague. So any other public records pertaining to, you need to target specific documents you're looking for. So anytime you see this, any other public records, that's like a ding, ding, ding flag that, it's going to be too vague. And so that's when you can ask them, hey, this is too broad. You need to narrow it down to specific documents you're looking for. So you're allowed to do this, and it says not discovery. You're allowed to do this in discovery. You're allowed to ask for all documents. The Public Records Act, as I said, is not discovery. So you have to be a lot more specific. So when you guys are drafting these requests, keep in mind that any other public records language is a huge flag to municipal lawyers that, what they're asking for is too broad. And then this box right here is just showing you that, like, a lot of times they'll specifically say, if you're going to withhold documents, you need to identify the documents withheld and a written explanation for withholding them. So, like I explained earlier, that's something that the requester is entitled to. They talk about what costs are recoverable. Like I stated earlier, compilation costs are recoverable. So they kind of try to say that they aren't, but they are. And like I said, we look forward to receiving your initial response within 10 days. So this is someone who clearly knows that, we're not always allowed to get the documents within 10 days. It's just the initial response that they'll get within 10 days. Okay. All right. Legal billing invoices. So this has led to a lot of litigation, and we finally have gotten some clear answers. So because the invoices are confidential communications within the meaning of Evidence Code Section 952, they are exempt from disclosure under Government Code Section 6254K. So I think I go into, no. So legal billing invoices, a lot of times, as you guys will know, a lot of times they'll have entries of specifically the works that's being done, things like that. So the courts have ruled that the work, those descriptions are privileged, and so since they're privileged in court under evidence code, they're also prevented from being disclosed under the Public Records Act. So if people want, like I mentioned earlier, if people want to know the cost of a certain litigation and it's after the time that litigation has ended, maybe you'll give them an invoice that shows the cost, but you're going to get all of those entries are going to be redacted because it reveals kind of the strategy of the lawyer and things like that. Police reports are always a big deal. It's probably one of the most common public records requests we receive, and all agencies do it differently. Some agencies will just give police reports because they don't, want to deal with the intricacies of the law surrounding police reports in the Public Records Act. A lot of people think you're entitled to just get a full police report, but that's not the case. So while actual copies of law enforcement investigatory records may be exempt from disclosure, certain information contained within those records must be disclosed. So a lot of times police reports aren't actually required to be disclosed, but there is information within those police reports that must be disclosed. That information includes factual circumstances concerning an arrest, including the name and description of the arrestee and charges associated with the arrest, and factual circumstances concerning complaints and requests for assistance, including a description of what crimes were alleged, whether any weapons, property, or injuries were involved. There are also circumstances where the requester matters. So, for instance, a victim or a victim's representative is entitled to more information than some random person requesting a police report. So it's always important to understand what information you're entitled to in regards to police reports, because it's not always a lot of information, and you're definitely not always entitled to the full police report. Latest development. So in 2018, the California legislature passed SB 1421, the Right to Know Act, which gives the public the right to see certain records relating to police misconduct and serious uses of force. So what must be disclosed? Records related to any incident where a law enforcement officer fired a gun at a person and used force that resulted in serious injury or death. Records related to incidents where the agency found that an officer committed sexual assault against a member of the public, which includes attempts to coerce sex or proposition sex while on duty, and records related to incidents where the agency found that an officer engaged in dishonesty in the investigation, reporting, or prosecution of crime or police misconduct. So you are entitled to any documents still in an agency's possession, no matter how old they are. So when this law was passed, we saw kind of an influx of request for any records that our police departments had relating to this conduct. So, I mean, it's in our small area, it's not a ton. I'm sure in bigger cities, this has been a bigger deal. So it's just something to keep in mind now that these records are disclosable. I think it kind of shows the trend of where we're heading in California as far as police records and the Public Records Act. I think they're going to become more and more widely available just because the call for transparency in police departments. So I expect this to only get more broad as time goes on. That was quick. I talk kind of fast, guys. I'm sorry. But if you guys have any questions, send them in the chat and I'll answer them. I also left my phone number for you guys, my email, if you guys ever have any questions about public records requests or anything. I also have a resource available to you guys here at this link. If you go here, there's like I think it's called The People's Business, and it's a guide that really goes through all of the exceptions to the Public Records Act, and it's really helpful. At least I know it's helpful for me. So if you guys are ever preparing requests for public records or reviewing one, this is always a really good resource to use. Will you be emailing the PowerPoint? I think Lane said, yeah, we'll provide the PowerPoint and recording of the presentation. So you guys will be getting that so you guys can review it. If you guys have any questions after reviewing it, you're welcome to send me an email. And thank you guys.